pleasant good morning, everyone, a Thursday morning, and welcome to Strictly Legal on WESN Content Capital. I am happy to be back. This is an all-new episode of Strictly Legal, and you are here, I am here, we are blessed to be alive. Of course, you can stream us on WESN CC as well as all social media platforms, including our podcast at Strictly Legal with Donawa.com. Of course, we are starting off with a new episode speaking about basically the recent Privy Council ruling when it comes to common law spouse entitlement with relation to a death of a spouse, a husband or wife, and the entitlement to the estate. And of course, we have two guests, one in studio and one via Zoom. In studio, I have with me Mr. Lasana Murray, attorney at law of 10 years practice. He practices out of Alpha Chambers, as well as Mrs. Bria Hosein-Seetahal, who is joining us via the Zoom. So without further ado, of course, our new times are 10 to 11 on a Thursday. Of course, we had a late start today, but however, we will get right into the program. So let me welcome first in studio Mr. Lasana Murray. Good morning, sir.
Good morning. How are you?
I'm well. Thank you for coming.
Thank you for the invitation.
Sure. And of course, via Zoom, we have Miss Seetahal, Bria Hosein-Seetahal. How are you, Bria?
I'm fine, thank you. Good morning.
Good. So today we are going to go straight into the topic of the recent Privy Council ruling relating to the common law spouse entitlement. However, just before, I know I would have done an episode relating to what is a common law relationship or cohabitational relationship, as well as whether it is by virtue of property settlement when someone separates, or by virtue of when someone dies, their entitlement. So Bria, just give us an overview of a common law and their rights in a cohabitational relationship setting.
Yes, please. So a common law relationship is based on two persons of the opposite sex who would have been living as husband and wife, and they would have been living as husband and wife for over 5 years. And under the Act, which is Chapter 4555 of the Cohabitational Relationships Act, this quantifies as a bona fide relationship, and therefore you are considered married once it is that it crosses over the 5-year period.
And let's deal with, for instance, when someone dies. So you are you are living with someone common law, and then your spouse dies. What happens next? What is such entitlement of that common law spouse?
So you would have to give a notice of interest within 28 days of the spouse that would have, or your partner that would have passed on. You have to give 28 days notice. Notice of interest has to be filed with the court under the Administration of Estates Act, Section 25. Further to this, then you would have to have a declaration basically made by the court as well that you were in a bona fide relationship with this said person in order for you to actually make an application to the court.
So therefore you're saying that in order for you to make an application for, let's say, letters of administration,
so
for the purpose
letters of administration or grant of probate, Mr. Donawa, yes, then you first have to file a notice of interest before the court within 28 days of your spouse's death.
And what sort of evidence in terms of, okay, how will the court be satisfied that that this person is in fact was in a bona fide relationship with the deceased?
The declaration would have to be made at the family high court. You are making an application before the court. In addition to that application, you would also have to attach affidavits of persons who would have known about the relationship. At least 2 or more persons would have you'd have to do affidavits or draft affidavits to that effect in support of your application. And those would have to be filed before the high court, before the family high court, in order for that declaration to be made.
All right, Lasana, as you're in studio, of course, Bria was saying that, you have to file an application before the High Court, etc. Now, what about challenges? Someone who is challenging the bona fide relationship of a common law spouse. Let's say, for instance, this person was married. They are separated from their common law spouse. They are separated from their wife or husband. However, they lived with someone, and then that wife or husband is now going to claim or file something before the court to stop the proceeds. Could you explain exactly if such occurrence can happen?
Certainly. So what can happen is that once the application is filed before the High Court, any interested party who wants to state that the relationship did not occur, they can do so, right? So they can file their affidavit in response to the affidavit that the applicant would have filed, stating why it is that they are saying that this cohabitation relationship did not exist, right? So there are other circumstances apart as well from the 5-year time period that can qualify as a cohabitational relationship. Another one is that if it is that the parties have a child in common, you can establish, well, sorry, let me backtrack a bit. A cohabitation relationship is once you're living together as husband and wife.
Yes.
Right? So that is one establishment that has to be made. Apart from that, thereafter, if it is that you're going to court to make an application for property settlement, etc., which is really called an adjustment order for cohabitational situations, in that case, you have to establish either one of three things. One is either that you have lived together for a continuous period of 5 years or more before you file the application. 2, that you have a child in common. Or 3, that you have made substantial financial, well, not financial, but substantial contributions, yes, whether financial or not, to the relationship itself, yes, right? So if you have established that, then somebody can try to counter that and say, well, listen, they either didn't have a child in common, it's not really their child. 2, they did not make these substantial contributions as they are alleging. Or 3, they did not live together as husband and wife for this period of 5 years or more preceding the application. So if it is that they can present facts to the court to support those assertions, then it is that they may be able to challenge the allegation of the cohabitational relationship.
All right, let's take a break and we'll be right back with more of Strictly Legal. I have with me in studio Mr. Lasana Murray, attorney at law, as well as via Zoom, Mrs. Bria Hosein-Seetahal, attorney at law, and we are speaking about the common law relationship and the entitlement, specifically with respect to a recent Privy Council ruling. And of course, last week, I believe it was Sunday, in the Newsday would have quoted, or rather the story, Common Law Wife Scores Victory in Privy Council. And just to read a bit of an excerpt from it, a common law wife has scored a major victory in the Privy Council for her share of her late common law husband's property. On Thursday, the Privy Council delivered its final order on costs in the claim Laurelie Ramcharan filed against the executor of her common law husband's estate and his children. Now, basically, the cost order stipulates that the executor of her late common law husband estate and their children are to pay Ramcharan's costs, which cannot be recovered or claimed against the estate. Now, this would have spun from a previous matter, and of course, the hearing of the previous matter, or rather the substantive matter, would have been heard on the 31st of October 2022 before the board, the Judicial Committee of the Privy Council, and a judgment was given on the 29th of December 2022. However, there would have been a final cost order, which was handed down last Thursday from the reports. Of course, persons are wondering, okay, what this is about. So let me start with you, Mr. Murray. Just give us a bit of an overview as to what exactly this case is and why it has reached to the Privy Council.
Certainly. So, in short, there was an individual. He lived in the States. He was deported. He came back to Trinidad and Tobago. He did a will. He did the will. He gave his 4 children the entirety of his estate, and appointed an executor. The executor went ahead, applied for the grant of probate at the High Court, and thereafter someone came along who we can term as a cohabitant. She came and indicated that, well, she filed a caveat wanting to stop the process, indicating that she had an interest in the property and that the deceased person, because he died, he did not account for her in his will, right? He didn't make adequate provision for her in his will. So the executor went to court to try to prove the will. So he filed what is called a warning. And then the respondent, who is the cohabitant, she would have filed a response indicating that she had an interest in the property. At some point in time throughout the court proceedings, the parties decided to enter into an agreement, right? So they said, listen, we would allow you to have a portion of the estate, no issue, no problem. What happens thereafter is that there's a disagreement in terms of what was agreed to, right? In terms of what it is that the cohabitant would have been able to get pursuant to the agreement.
Yeah. So
the cohabitant applied to the court initially, asking the court to do a number of things, right? And essentially to secure or to make a ruling on the validity of the agreement that the parties had made.
Yeah.
However, thereafter, the siblings said, listen, we didn't make this agreement, it was a fraudulent agreement, etc., etc. The court determined that they could not rule on the agreement that the parties made, and they would have had to wait until probate, the probate registry would have gone through the whole process. So the cohabitant didn't like that decision, so she went to the Court of Appeal. The Court of Appeal affirmed that decision as well and said, listen, we can't do that now. We can't determine the validity of this agreement until the probate is granted by the probate registry. They went ahead again to appeal that decision and went to the court, the Privy Council, sorry. Yes. And the Privy Council essentially said that, listen, we understand the backdrop of why it is that the High Court and the Court of Appeal didn't make that ruling on the validity of the agreement that the parties made. However, we have a different position. Our position is that, listen, we can make a determination on it, and they went ahead to do it, notwithstanding the reservations that the High Court and the Court of Appeal had in terms of the procedure, etc., which was the main contention was that between the High Court and the Court of Appeal was that because it wasn't, the claim that was before the court wasn't contentious probate proceedings, that they didn't have the jurisdiction to make that determination on the matter. However, the Privy Council have determined that the issue before the court was more of a contractual nature, as opposed to a probate issue that had to be filed in the probate jurisdiction of the High Court. So they determined, listen, it's just a straightforward contract that was done, and the court has the jurisdiction to deal with that. We have the jurisdiction to deal with that, and we will make a decision based on it, and they granted that particular part of the appeal, saying that the agreement was indeed valid.
Now, let's take up in there. I want to get to Bria.
Sure.
Now, Lasana mentioned with respect to the common law wife, I mean, it was already established that she was in a common law relationship. We would assume based on the judgment.
So, yes and no. To a certain extent, okay, so when the matter was in High Court, it was determined that yes, she did cohabit with the deceased Mr. Seetahal, right, which is Miss Ramcharan. However, the learned judge indicated that she could not have granted her or declared her as a cohabitant because she did not qualify under the Succession Act.
Yeah.
And this is because Mr. Seetahal, the deceased, was deported for a while back to Trinidad, and that will where he would have made Dr. Donawa the executor of that will was made 4 days before his death.
So are we saying that the court had never declared a common law?
So here's the catch to it. Yeah. Here's the catch to it, because this case is a real eye-opener. Yeah. Because the Privy Council declared that the compromise agreement, it was not fraudulent in any way, and it has good standing. What the children would have signed to, one of the clauses that they would have signed to was that she was a cohabitant of the deceased.
Okay, and that is where the court would have recognized that particular.
So that's why. Yeah, they would have. I guess that's how the article came out as common law wife. Yeah. You know. Yeah. Yes. Yes.
Now, Lasana mentioned with respect to a will that the common law wife did not make. There was no provision in the will for the common law wife. And of course, this can apply for, let's say, for instance, a married wife or husband died and he did not make a will and included the wife in the assets. Are we saying that that can be challenged, basically because you are married to this person or because you are a common law relationship? If I as a spouse do not make provisions for you in that will, that can that be challenged?
Yes, same thing. So under the Administration of Estates Act, it's just that there would be a particular percentage that the cohabitant can claim under the Act. Under the Act.
And yes. And of course, as a cohabitant, is it that they're entitled to half the estate as well?
Well, it depends. So
yes.
If it is that they are able to establish that they were in a cohabitation relationship, etc., they get the declaration from the court. It depends. So if it is that the deceased person didn't have any children, they can get the entire estate.
Yeah.
If the deceased did have children, then they will be entitled to half. If, however, in this particular instance, if it is that the deceased also had a wife, because there are many well, assuming that the deceased is a man, of course, there are many instances where someone may be very well legally married, but thereafter they may have separated with their wives, but they have a cohabitant, they are in a cohabitation relationship with somebody else. That person will be entitled to the portion of the estate of the deceased that they would have acquired during the period of cohabitation. So that is where it will go.
And I think that's important to establish because a lot of persons feel when I cohabited for 5 years or 10 years, and it means that the wife cannot get anything.
Definitely not. No.
Right. And I see Bria laughs. Did you have did you have a comment further?
I'm sorry.
No, sorry. I thought you had something further to add.
Oh, no.
But of course that it's important to note that so therefore that is where they can only claim a percentage.
Indeed, so.
Right. Yes. A percentage of what was acquired during the course, let's say, of the common law relationship.
Indeed.
During the course of the yes, correct.
Right. So let's go back to this Privy Council ruling. So this is a matter of contract law rather than establishing whether the will was valid.
In the end, because what happened is that over the course of the proceedings, what the cohabitant claimed changed. So initially, she claimed a number of things. At the Court of Appeal, she claimed she lessened the amount of lessened the amount of reliefs that she sought from the court. And then when it reached to the Privy Council, it was really just at that point she had abandoned many of the claims that she had made, and really just wanted a determination on the validity of the agreement itself. So that's why it changed as it went ahead to the higher courts.
So is it that? So are we saying that that basically, if a will is made, someone challenges a will and there's an agreement outside of that particular will, are we saying that that is valid? Is it that the contents of the will can be set aside, right, for the purpose of maintaining an agreement?
It certainly can be varied. So if it is that the deceased has a will, what happens is that the beneficiaries of that will can make an agreement amongst themselves or with any other person to vary the terms of the will in any way that they wish. So if it is that the beneficiaries, according to the will, wish to dispense with the will, in the estate in a different way than the deceased person had intended, they can come together jointly and make that determination. So what they did in this case was that they came together with this next person, the cohabitant, and they all entered into that agreement, and this agreement had the effect of varying the terms of the will.
So therefore it can only be valid prior to the grant of probate, or if the probate is granted, can the agreement stand?
Certainly they can amend the documents at any point in time. However, if it is that they intend, well, it's two different ways, sorry. One hand, if it is that it's done before the grant of probate, it can vary the terms of the will. It can be done after, because if it is that the probate is granted, the probate will be granted upon the original terms of the will. So you can't change the terms of the will after the probate has been granted, but you can determine to dispense with the estate or the assets of the deceased after he has passed away.
Now, basically, this is a landmark decision, right? And there has been a lot of variations in terms of even counsel or counsel for both parties who are at odds in terms of this area of law and whether or not the board of the Privy Council can rule on such matter because it's a bit peculiar, etc. How do you think moving forward this can assist other areas or other persons who may have difficulties or who may have agreements, but the agreements would not have stand because their attorney said, well, that cannot stand because there's a will, basically. Okay. Bria? Bria, are you hearing me?
Yes. Hello?
You froze?
Hello?
Oh, yes. So what I'm saying is that
yes.
how
Sorry.
yeah, that's okay. Where do you see this case moving forward in terms of this landmark decision and how persons can move better to agreeing on certain terms and conditions apart from a will?
First and foremost, the agreement, this compromise agreement that was made, it really went into specifics with regards to what Ms. Ramcharan, which is the appellant, what would have been done in order for certain things to be changed. So, for example, she wanted to be the executor to be changed from Dr. Donawa to herself. One of the other things was that in exchange for certain proceeds or certain percentage of the proceeds of the Florida estate, she would have been paying off the property for the taxes in the U.S. Right, and then they also would have agreed that is the children and Miss Ramcharan, they would have also agreed that they would each receive 20% of the value of the estate of all the properties in Trinidad. Yeah. But initially, what she really claimed for, and this question arose before the High Court and the Court of Appeal, was that her pleadings really was for just Laura's Valley, which was one property which she stated that
and that's in Trinidad.
And that she contributed to.
Yeah. She
claimed that she contributed to this particular property, and this was really what initially sort of started this whole issue. But the agreement itself, remember that this would be something that would have what was challenged was the contents of the agreement, the compromise agreements that was signed, because the children were saying that they were claiming fraud, as was indicated before. They were indicating that they did not recall all these documents, all these pages. That's how they referred to it.
Yeah, they referred. They basically said that they would have manipulated
they didn't
the
have
entire
all these pages when they were signing, and then they denied that the document was properly executed as well. But in so doing, in cross-examination, it was shown that the power of attorney for one of the siblings was actually held by Terrence, who is another child of the deceased, and also I believe the husband of Miss Ramcharan. And he held the power of attorney for one of his siblings, and he would have signed for her. So the challenge again with the compromise agreements was that they indicated that yes, that was their signature. At the end of the day, it was their signature. So everything that was, included, all the contents of the agreement was proven to be valid before the Privy Council, and there was no sign of fraud. And as you would know, Mr. Donawa, fraud is a very hard thing to prove.
Particularly.
Yes.
Now, Mr. Murray, this is very interesting that persons can, let's say for instance, this gentleman made a will 4 days before he died, excluded someone who he would have partnered with.
Correct.
And this is where the law comes in to protect such individuals. Right, for instance, if it's your common law spouse, from feeling like a sense of dejection, rather, in terms of their entitlement, right, and and basically this is where it's important to seek legal advice,
Certainly.
right, from persons who are known in the law,
Yes.
so that you don't feel as though you, I mean, there are certain legal reliefs, right, that you can achieve, right, to circumvent whatever disadvantage.
Correct. What persons can do as well is that when preparing wills, if it is that you intend to exclude a particular person who may be a dependent or who may consider themselves to be a dependent of you, what you can do is you can put into the will. You can account for them basically. Even if it is that you don't want to give them anything, you can say, listen, I make no provision for this particular person for these reasons. Right? And thereafter, now, anybody who's reading the will say, listen, but they provided for you, but they didn't want, they considered you. Because what happens sometimes is that somebody can, slightly different topic, but they can challenge the validity of a will, stating that there were suspicious circumstances, etc., because they would say essentially that this person would have never done a will and excluded me from it. So clearly, the fact that I am not mentioned in the will, that is a suspicious circumstance or some other factor that the court can take into consideration in determining the validity of the will. So it's always suggested that if it is that you're going to exclude someone who you think may be able to make a claim, you should at least account for them in your will, whether it is you give them something, a little something, minimal, or you say give the exact reason why you make no provision for them in the will as well. I
mean, and they can still challenge that. They can still challenge that reason, but again, if dead man tells no tales, as they say.
Yes.
Well, there will be, I mean, there are certain things that they can claim so that in the Succession Act, I think it's Section 97, they give certain factors that the court can take into consideration when determining if it is that the person ought to have made financial provision for this applicant. So if it is that you are able to prove these things, fair enough, you may very well be entitled to some portion of the estate.
Yes.
But if not, then you would be in a tough position.
Well, you know, long ago, when you read wills, I'm sure even in law school, when you see husbands or wives making provisions for their spouse of $1, right?
Exactly.
$1 entitlement. So they can't challenge because at the end of the day, they would have provided for them as part of the requirements. And Bria, how important it is to make a will? I mean, we've seen where this person would have made a will but excluded other parties. But how can you stress on the importance of a will?
Well, that's the thing. That's the difference between, I would say, every other case and this one. This one is quite unique because she was left out, yes. Just remember that this will was made 4 days before his death. And it didn't even come down to the will itself. It came down to the fact that an agreement was made between the Miss Ramcharan, the appellant, and the children. Yeah. So that compromise agreement, that's the main thing in this matter. That's the main topic in this matter. But
at the end of the day, a will, I mean, it is still important that you make provision.
It's very important, of course, because important.
If you die, as you call incestate me without a will, then that can become a bit more complicated.
Certainly.
Of course.
A lot of people ask if it makes sense to do a will. I would say yes. Depends on the circumstances, the family arrangements that you have. Because it may very well be that in the arrangement that you have, doing a will may make absolutely no difference. So it may be a case that you may be a married person with no children. You know when you pass away, everything is going to your wife, right? Or in the case if you're unmarried and you just have children, everything will go to your children. But in the circumstances where you want to...
Where you have a wife and you have a common law wife and you have children from different marriage, right? From different relationships.
But then you have situations where persons, their family arrangements are not ideal. So they may not want to give one particular child something, or they may want to give one particular child more, or they might want to give their wife more, or they may want to give another family member who under normal circumstances wouldn't be entitled to any part of the estate. Because, of course, once it is that you, just to reiterate, once it is that you don't have a will, half goes to the spouse, the other half is distributed among the children equally. So if it is that you don't want that particular arrangement and you want to do it in more particular terms, in terms of, I want this property to go to this person, this cash in this bank account to go to that person, then it makes more sense to do a will so that everybody gets what it is that you wish that they get out of the estate.
Now, let's say, for instance, you are married and you have, let's say, 4 children with your wife. and then you have a child outside,
Sure.
and you make a will and only provide for the 4 children, can that child through their parent challenge the validity of that will?
Certainly.
For the provisions of that child, who at the end of the day, regardless of whether it's made out of wedlock, it is the child.
But they would be entitled still.
Certainly.
It would still be a child of the deceased.
Certainly, and if it is that it's in the will, then they can challenge it. Same factors to be considered by the court, Section 97 of the Succession Act. Once it is they can prove these things, then they may very well be entitled to some provision under the estate, or out of the estate rather.
Right, and yeah, go ahead.
Sorry, I just wanted to add to Mr. Murray, but there are certain aspects that you also have to take into consideration as well with certain children or certain offsprings, whereby they may not have the deceased person's name on a birth certificate, or so they have to have a declaration made by the court as well.
A declaration of a paternity order.
Yes.
And we have seen where there was a challenge with respect to that particular requirement recently, and the court would have adjudicated and that. Can we just touch quickly on the whole paternity issue? Because a lot of persons sometimes think, oh, paternity, but the person done dead. How could I now claim paternity? Could you just explain?
Sure. So in this particular instance that you itemized, where it is that somebody passed away, somebody's father passed away, but their name is not on their birth certificate, they can apply to the family court for a declaration that that person was the father. They can prove this by a number of ways, right? So they file your application, you file your affidavit showing the reasons why it is this person is your father. Ideally, you get 2 supporting witnesses as well to support what you have asserted. How you can do this, or the information that the court may be more consider a bit more, is that one, for example, you may want to attach a funeral program where they state that you are one of the children of the deceased person. You may want to attach photographs as well. You may want to attach maybe a letter that he may have done on your behalf, giving you authority to use his house for a utility bill. Any documentation that you could provide to the court to show that this person was indeed your father, you would attach to your application. And you also get persons in the area and or family members of the deceased who would not likely lie on the deceased to assert that you were indeed the child of the deceased. And once the court is satisfied, they can grant the order. They carry the order into the Registrar General's Department, and they would now insert the father's name on your birth certificate, and then you can get a new certificate with your father's name on it.
Right, and also in terms of applying for an estate, that is that in that way. So it's not a matter of you exhuming the body of the deceased and having to now do DNA testing to establish paternity, right? No. And of course, we have seen where that was challenged, and obviously it was. it is quite clear in terms of the law when it comes to probate and the declaration of paternity when you don't the deceased is not on the child's. The claim on birth certificate.
The birth certificate, yes.
Yeah, right. So there are obviously different ways and processes. Of course, it's just a matter of persons being knowledgeable, and seeking the required advice to really put forward their case. Bria, any closing statements? I know we're out of time, of course.
Oh, already?
Yes.
I hope that the public is more knowledgeable after this program, and it gives them some more insight into the case, as well as some of our colleagues who would have also read the judgment. And Mr. Donawa, I want to tell you thank you for inviting me on your show.
My pleasure, and of course this is a very interesting case, and I really hope that it evolves, and the law, particularly in Trinidad and Tobago, evolves as well. Mr. Murray.
What I would say is that I'm glad that the case allowed us the opportunity to bring this topic to the attention of persons.
Yes.
I would like to highlight as well that the cohabitational relationship is not restricted to 5 years. So you also have the issue where you'll have a child together, and one person has made substantial contributions, right? But it must always be that you'll live together as husband and wife, and you'll discharge those responsibilities towards each other. But it's not a requirement for the 5 years. So you can go to the family court, get a declaration, and do your matters after, whether it is you're applying for probate, etc. And you can, or it is you want a property adjustment order pursuant to a relationship, etc. So thank you as well for your invitation, and happy to be here.
Thank you so much, guys. And of course, I will call on you all again, just in the event that there's some more developments. So thank you very much, Mr. Lasana Murray and Mrs. Bria Hosein-Seetahal, both attorneys at law with the jurisdiction of Trinidad and Tobago. Guys, it is a wrap. You have been watching Strictly Legal on WESN Content Capital, of course. You can catch our replays as well as on our content at Strictly Legal with Donawa.com, as well as WESN.cc. See us next week once again for a new episode. Hopefully we have the DPP here with me. So let's cross our fingers and just be in touch. Stay safe, be well. Have a blessed day. Goodbye.